Thank you, Mr. Speaker. Members, today we're very fortunate. We are fortunate that we have the opportunity to vote for a resolution that can provide a solution as big as the problem. One of those measured problems that we have today is the national debt, $22 trillion. Additionally, we have another $122 trillion in unfunded liabilities. These unfunded liabilities used for Medicare, Social Security, Medicaid. It's important to understand the unfunded liability part because this debt is being raised for just public consumption, which means that the current advantage is only to the current generation, and that's where it becomes a little more personal for me. As your youngest colleague, I beg you to do something about this with me, but not just something about it. The exact remedy that the Founding Fathers envisioned for times like ours. And it's not just the debt, as you guys know, that's the issue. It's the general overreach of the federal government in our everyday lives. It's the regulatory crisis, federal attacks on state sovereignty. I would say that federal government has essentially turned our state legislature into regional agencies rather than respecting us for the truly independent states that we are. The biggest issue for me, it's the federal takeover of the decision-making process. Who decides what law shall be is even more important than what is decided. Washington, D.C. currently has control over roughly 65% of our budget. So my question is, are we going to let D.C. continue to decide if they know what's best for Arkansans, or do we want Arkansans to be able to decide for themselves? That's what I believe. It's what the majority of our Senate colleagues believe. It's what these petitioners believe. It's what a high percentage of Arkansans believe. And I hope you guys can show that you believe the same thing today. So this resolution calls for an amendment convention for three things in particular: imposing fiscal constraints on the federal government, limiting the power and jurisdiction of the federal government, and limiting terms for the office of its officials. By the way, since I started talking probably 2 minutes ago, federal debt's gone up $1 million a minute. I have to tell you, I started somewhat as a skeptic on this particular issue, and through history, studying logic, frankly, and a little bit of precedent, I've come to the following conclusions that I want to share with y'all, because I know that generally most of us agree there is an issue, but a lot of the conversation is about, is this the right remedy? As I mentioned, the Article 5 procedure, the application and convention procedure, is the exact remedy that the Founding Fathers envisioned for times like ours. They set up these mechanisms so that the state legislature could respond, you guys, the people, if the federal government ever became abusive or dysfunctional. So the question you have to ask yourself is, do you feel like that is the case? Is that happening? This is the tool that the founders designed for this very circumstance. Amendments have historically been very powerful reform tools. As a matter of fact, they seem to be respected more by the courts and other federal agencies more than the actual Constitution. Amending the Constitution will help our country. I've heard many individuals object to that, saying that the Constitution isn't the problem. It's actually the federal officials. And I believe Arkansas, we send some pretty excellent delegates to D.C. So really, I would tell you that most of the problems our country is facing is the result of constitutional interpretations that capitalize on ambiguities. General welfare clause being interpreted as unlimited powers comes to mind. We can restore this federal government to its proper limited place only by clarifying the original meaning of those phrases through constitutional amendments. A big, important point I want you guys to kind of reflect on is this process is a constitutional right itself. It's a right guaranteed by the Constitution, like the right to vote, like the right to publish whatever you want. Some of my conservative colleagues here talk about the rights of the states. This mechanism was set up for the people to circumvent Congress to make reforms in the Constitution they thought were important. So you, as state legislatures in this process, get to act as actual direct representation of the people, hence it being a joint resolution. This is a right given to us by our founders, arguably the most important check to our entire Constitution. Another point, Convention of States has plenty of checks and balances. I know folks are worried about risk associated with such a process. I would make the argument that our founders were masters of checks and balances and that they put many safeguards in place to ensure that a convention would never run away. 38 states must ratify any proposal coming out of said convention before any changes would be made to the Constitution. There are far more checks on a runaway convention than on our current runaway Congress. I would say runaway courts, runaway bureaucrats. Now, the opposition, I'm sure you hear, will say things like, now is not the time in today's political environment with unlimited political spending, with fear of abolishing the Electoral College, and they'll say things like, shouldn't we be afraid special interest groups will rewrite our entire Constitution? No. How do we know that's the rule? There are over 400 applications out there that have been submitted to Congress for an Article 5 convention in the history of our country. As Representative De La Rosa has pointed out in the past, in Arkansas, there's several. But the reason we have never had a convention is because Congress refuses to certify that they are on the same subject matter. There has never been 34 applications seeking a convention for the same purpose. Courts have verified that that's what has happened. We have a long history in the country of states applying for this Article 5 conventions, but we've never been able to get there because the states have never agreed or aligned on the subject matter. In order for this convention to happen, it requires, as I said, those 34 states to aggregate. That aggregation requires that the applications are identical or substantially similar in nature in order to get the convention. Now, states can instruct their respective delegates to entertain a more narrow scope than what is within the aggregated application, but they cannot broaden the topic beyond the identified in the 34 past applications. Another thing I hear from the opposition, many delegates will not be bound by the states when they get there. They believe these delegates will have fuller powers. And I would say in the context of the Constitution, and if you read Article 5, their power is drawn specifically from Article 5 of the Constitution and is thus inherently limited. The language of Article 5 specifically indicates they cannot draft a new Constitution in total. It states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution. Note the language, as part of this Constitution, not a new Constitution in total or anything like that. And after whatever comes out of the convention, it has to be approved by 3/4 of the states. So anyone to say we're going to get a new Constitution out of this process is, you're saying that the convention would magically exceed what they are bound to in the first place, and then 3/4 of the states would want to get rid of the Constitution after the fact. Article 5 says Congress calls the convention. Congress can't take over the convention of states. Congress's role is limited to the call, which sets the date, time, and locations. This legal term is referred to as ministerial secretarial role. In this role, Congress is acting in a limited administrative capacity. I've heard in several, I would say just the opposition claims that Congress would perhaps use Article 1 powers that under the Constitution and could simply take over the Convention of States once it's called and do as they will with our Constitution. But that's not true. The question has already been decided in federal court. Idaho versus Freeman, 1981, the court found that, quote, in proposing or acting on a proposed constitutional amendment, Congress is not acting pursuant to its ordinary legislative powers found in Article 1, but acts according to those powers granted under Article 5. Thus, Congress, outside of the authority granted by Article 5, has no power to act with regard to an amendment, i.e., it does not retain any of its traditional authority vested in it by Article 1. I've heard the opposition point out a Congressional Research Service report found that Congress has previously proposed broad responsibilities for itself regarding the Article 5 Convention. What they do not tell you is that every single one of those proposals were defeated or not even brought up by a debate in Congress. Even Congress knew it didn't have the authority to take over a convention of states. This very same Congressional Research Survey, cited by the opposition earlier, has this to say in conclusion about a runaway convention. Finally, the report noted that the founders did not provide unchecked power to Article 5 Convention. Every amendment proposed would be subject to the same conditions faced by amendments proposed by Congress. The notion of a runaway convention succeeding in amending the Constitution in a manner opposed by the American people is not nearly remote, it is impossible. My final point, the Article 5 procedural will not threaten the Constitution. We want to use the Constitution to restore the Constitution. And my question to you, for those that say that, is which Constitution are you talking about? Are you talking about this, pocket Constitution that we like to carry around, or are you talking about this?
Representative Love, for what purpose?
Point of order.
May make your point.
I would ask the parliamentarian if there are use of props in the well.
Just to be clear, what I'm hearing is the Constitution is a prop.
I understand that, but you're using it as a prop.
All right, we'll vote for this resolution so that we can make this look a lot more like this.
Representative McCollum, to Representative Love's point, you are allowed to bring a book to the well, but you may not use a book as a prop. And at this point, Representative McCollum just brought a book to the well, so it is permitted.
Thank you.
By a vote of 56 yeas and 40 nays, the resolution is passed.
Go to conventionstates.com, press the button, sign the petition. More importantly, get 10 of your friends to do the same. When you sign the petition, then that sends a letter to your state legislator. You go on the list in their district as a supporter. We deliver those lists to the state legislators. It means something to them.